Hi, welcome to Scherable. I'm Bill Scher. This is the third installment of my YouTube commentary series, and today we are going to talk about, would Amy Coney Barrett strike down the Affordable Care Act? As I think many have noted, Joe Biden and other Democrats are far more eager to talk about this nomination in conjunction with the Affordable Care Act, a little bit less so in regards to abortion, although I believe Kamala Harris did talk about that recently. But I think there is an understanding that they will appeal to a broader swath of Americans to talk about the threat to pre-existing conditions if the Affordable Care Act is struck down. That is something that has wide popularity than abortion, even though there is pretty broad majority in support of Roe. It is, by its nature, a much more divisive and complex subject. And if I'm Joe Biden, I most certainly would suggest that the Affordable Care Act is at risk. It is legitimate to note that Donald Trump is actively trying to overturn it, is litigating that in the courts right now. There is a case headed that the Supreme Court will hear oral arguments on next month. So it is not inappropriate to suggest he would put somebody on the court who would want to rule in his favor. And on top of that, there is a law review article, it's a book review that Barrett wrote that suggests she thinks the Roberts opinion, the controlling opinion that upheld Obamacare in the first place, that she thinks that was errantly decided. Before I get into the details of that review article and what I think the import of that is, I want to also note, I understand that a good number of Democrats, I believe some in the Senate, as well as those rank and file Democrats, some would argue, you shouldn't even engage the Barrett nomination at this level. You shouldn't be delving into her judicial philosophy and her opinions from her short tenure as an appellate judge, because the whole process is illegitimate. The nomination is illegitimate. As Mitch McConnell said in 2016, in trying to and successfully blocking Merrick Garland, it's not the person, it's principle. And the principle that the Republicans laid out 4 years ago, they're not adhering to today. So Democrats could legitimately and should legitimately say, it's not the person, it's the principle. It's the principle that Republicans set 4 years ago and are violating today out of self-interest. So if I'm Joe Biden, if I'm a Democrat on the Senate Judiciary Committee, like Kamala Harris is, I wouldn't be talking about what I'm going to talk about right now. What I'm talking about right now doesn't have great short-term political utility and is not the most important point. It's not just about being utilitarian. There is a point to convey about the legitimacy of this process, and getting into the weeds does convolute that. So understand that I accept that political logic, and what I'm doing right here is more just between us. So is it accurate to look at Barrett's law review essay and conclude she's going to strike down the Affordable Care Act? Well, what's important here, in my opinion, is you should be careful with any kind of truncated quote or paraphrase that's flying through the interwebs. I think that's correct as a general rule. And I think it is important in terms of Amy Coney Barrett, not because we should be gentle to this nomination in the interest of chivalry, but we should just be educated news consumers and understand what we're dealing with. And I think having an accurate, nuanced sense of where we are does help with any kind of political strategizing. So if you look at the actual article that she wrote. And it was an article that's a book review of somebody else's book. Called the book was called Our Republican Constitution. And that was written by a gentleman named Barrett. She writes, Our Republican Constitution, that's the name of the book, is animated in large part by Barrett's frustration with what he regards as a misguided attachment to judicial restraint, particularly on the part of conservatives. In NFIB versus Sebelius, that's the case that upheld Obamacare in the 5-4 ruling. In NFIB versus Sebelius, the inspiration for Barrett's book, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. He construed the penalty imposed on those without health insurance as a tax, which permitted him to sustain the statute as a valid exercise of the taxing power. Had he treated the payment as the statute did, as a penalty, he would have had to invalidate the statute as lying beyond Congress's commerce power. So let me just break that down a little bit. Roberts wrote for a 5-4 majority, but he actually did not agree with the other 4 liberals. The other 4 liberals said there's the commerce power, the commerce clause in the Constitution. Congress has the power to regulate interstate commerce. And we think that is sufficient to say this law is constitutional. A lot of conservatives don't agree with that, think that is stretching the text of the commerce clause to capture far too many things that liberals want to do. And they have often ruled to restrain the use of that power as constitutional justification. So Roberts doesn't go there. He says simply that there's also the power of Congress to tax. And the original Affordable Care Act law said there's an individual mandate. You are legally obligated to purchase insurance with a few exceptions. And if you don't do that, you pay a penalty through your taxes to the IRS. In fact, the exact wording of it it's called the shared responsibility payment. If a taxpayer who is an applicable individual fails to meet the requirement, there is hereby imposed on the taxpayer a penalty with respect to such failures in the amount determined. Any penalty imposed by this section with respect to any month shall be included with a taxpayer's return under Chapter 1 for the taxable year, which includes such month. So is that a tax or is that a penalty? Robert says that falls under the realm of Congress's taxing power. Many Republicans and judicial conservatives were apoplectic at this. They often leaned on Obama's political arguments, him saying this is not a tax. But as far as I'm concerned, the political rhetoric around it is really irrelevant. What matters is what's in the statute. I think you can read this law and say this is about taxes because it's about what's happening within a tax return being paid to the IRS, et cetera. But at least Barrett, when she writes, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute, is she speaking for herself there, or is she speaking in the voice of Barrett? I think it's a little unclear, in my opinion. You could read it either way, and I would not be shocked if in the hearing, Barrett claims she was paraphrasing Barrett and not giving her own view. But leave that quibble aside. Let's go forward on the presumption she is actually stating her own view here. If she is confirmed, which we all expect that she will be, and she is seated on the court in time to hear the arguments for this case, which happen on November 10th. So there is a chance that perhaps she that this gets delayed to some extent and she's not confirmed until after November 10th, then she's not seated on the court for the oral arguments. Seems like chances are she will be, but that is a little bit up in the air. If she is on the court to hear this case, she is not going to be reviewing this argument over again, because it's a new case that's going through the pipeline. Because what happened since this case was ruled, the Republican Congress under Trump, when they couldn't repeal Obamacare completely, they instead were able to pass tax reform with a partisan majority vote through the budget reconciliation process, circumventing a filibuster. And in that tax reform bill, they said the individual mandate penalty under Obamacare, under the Affordable Care Act, is hereby $0, which was an effective repeal of the individual mandate. So since then, the lawsuit got filed by several Republican attorneys general, state attorneys general, saying if there's no individual mandate anymore, then the linchpin of the Roberts ruling that this is constitutional under the taxing power is now moot. And thereby you have to treat the entire law as unconstitutional and strike it down. So there was an appellate court, I believe it was a 2-1 ruling. It wasn't the full Fifth Circuit. It was a small panel of the Fifth Circuit that ruled 2-1 to agree with that the whole thing's unconstitutional. They didn't insist it should be implemented immediately. They sent it to the lower court to review what's called severability. I'll talk about that in just a second. But then the Supreme Court has stepped in and said, okay, bring it to us. We're going to take it. So they are going to review 4 aspects of this case. One is, I think, the biggest one. We'll forget to the biggest one. One is the question of standing. Do the litigants have the standing to bring this case? That was actually a point of contention in the lower court ruling. The one dissenter said that the litigants did not have standing. They failed to prove they are being harmed by this $0 penalty. And so it's non-existent individual mandate. And so they have no standing to bring the case. The majority in that ruling said they did have standing. The Supreme Court is going to review that piece of it. The other big piece of it is the question of severability. If you decide that this piece of it is unconstitutional, do you have to throw the entire law out with it, or can you sever that unconstitutional part and keep the rest of it? There are a couple other elements that they're going to review. That if they do find it unconstitutional, is it enforceable nationwide, or should it be unenforceable only in certain parts? But the severability and the standing, I think, are the 2 real big things here. So in my reading of Barrett, Amy Coney Barrett, it's not evident to me. I can't look at the article she wrote and the comment she made about the Roberts opinion. I can't look at that and presume it's a guarantee she is also going to have the same view, the conservative view on standing and the conservative view on severability. And when I say conservative, I mean politically. Is she going to approach this in a political way, the partisan way? Is she going to bend the legal arguments toward her preferred political position? Now, she's written a lot saying that judges shouldn't do that. And you can look at that and say, well, that's bogus. Of course she's going to say that. Doesn't mean she's not going to function that way as a judge. And I don't know what she's going to do. I don't know how partisan she's going to be if she's on the court. But it is possible that she is more interested in being a constitutional purist in certain ways that are not relevant to severability precedent. She may, from a political standpoint, want to be seen as more of a pragmatist. She may not want to engender the kind of backlash that would ensue if she was a Trump appointee who got confirmed in a railroaded process. And one of the first things she did was make a political decision to junk a healthcare law that is benefiting millions of people first chance she gets. We just don't know. That's not to say that we should give her the benefit of the doubt. That would be just fine if she was confirmed. That she will not have a severely negative impact on the court in general in a myriad of areas that we can't even fully foresee at this point. But I do think you want to be careful not to presume more than you know at this juncture for a couple of reasons. One, from an attorney standpoint, if you are an attorney that's going to argue cases before the Supreme Court, you really want to have as much of a precise understanding of the specific judges' philosophies as you can, because if you don't, you're going to miss opportunities. Now, look, let me digress for a little bit. When I was an early blogger in the Bush years, I actually was one of the few people who was really adamant about opposing John Roberts, as well as Sam Alito. And in fact, I was working at a women's rights legal organization, and we were part of a coalition, working together on judicial nominations in the Bush years. And I was really eager to get people to change how they approach these things and be more combative, to vet all the potential candidates before they get nominated and then hit the ground running right at that nomination, try to win that news cycle in the first 24 hours. Because, as I argue to folks, if you lose that first news cycle, the game is already over. And we knew there was a chance that a guy like Roberts would get nominated who didn't have a long paper trail. And so my argument was, in that circumstance, you did not want to concede anything. You wouldn't want to say, well, he seems like an upstanding guy, let's wait till the hearings and see how he looks. You want to come out right out of the gate and say it's not appropriate to nominate somebody with no paper trail. It's not appropriate to hide the ball for a lifetime appointment. If all you have to do to get on the court is to be crafty and keep your mouth shut, and when you get there, you can go wild. That's not a good process. Now, most people in the progressive coalition didn't agree with how I wanted to approach things, and that's not how it happened. And Roberts got a ton of positive press out of the gate, and there was barely a fight. And then when Alito came down, who was more of a guy with more of a paper trail. In fact, if you may recall, Bush first nominated Harriet Miers, who had less of a paper trail and was not even a sitting judge. And conservatives sandbagged that nomination because they were ready to push the point. Time to nominate people with demonstrably documented conservative records. And they won that fight. And in fact, I recall I was arguing this point on the Huffington Post blog with a woman named Flavia Colgan, who was a bit center-left, but was defending Alito, and I thought that was nonsense. And Cenk Uygur, who did host the Young Turks, still hosts the Young Turks, had us on for a debate because at that time Cenk was undecided what to do, and he wrote even in a blog post at Huffington Post that he thought Roe was wrongly decided, even though he's pro-choice, and wasn't sure if Alito was going to be kind of like a balls and strikes judge or be more of a partisan. And he wanted to have us on for a debate, and we had the debate. And then afterwards, Jen came out hard against Alito and did a whole, 24-hour show or something other to oppose him. But I'm going on this tangent just to remind folks that I wasn't always the jackass moderate that I am today. I was arguing for an aggressive approach to judges. And the Roberts and Alito cases are interesting to me in retrospect because the two aren't the same. Alito has been a pretty knee-jerk conservative judge. Roberts, as we know, has not. Roberts has proven to be more of a swing than I thought he was going to be at the time. I had told myself that it was all a big conspiracy and he was going to be a reflexively right-wing judge once he got there. And whether that was the intent, this didn't come forth as planned, or Roberts changed once he got on the court. I mean, Roberts has taken some hard right views, of course. He has undermined the Voting Rights Act. He has undermined union organizing in the Janus versus AFSCME case. He did vote for Citizens United. So it's not like he's some true moderate here. But he has broken ranks from time to time, increasingly as of late. Is that because that's the guy he always was, or because there's something about the lifetime appointment, something about the system, once you're removed from partisan political pressure and you're free to let your mind roam, you end up doing unexpected things. I can't read his mind, I can't know exactly, but for whatever the reason, he is where he is today. And so that's why I am reluctant to jump to every possible worst case conclusion, even though in the case of Barrett, there are obviously a gazillion red flags. I mean, don't get me wrong here. She's on the record as being soft on stare decisis. She has said life begins at conception. She has made some comments that suggest hostility to Roe v. Wade, although she has, and when that's not up to debate, she has ruled as a appellate court judge in cases, I mean, there were dissents, but she would weaken Roe v. Wade. She's on record having done that. Whether she would actually overturn root and branch, that I think I can't make that jump based on what's out there, even though there's reason to worry. There's also reason to suggest she might think that that's a bridge too far from a political standpoint, that she believes in stare decisis enough to not go that far. But there's almost no dispute that she would at minimum weaken it. So none of this is to suggest that she is going to be a swing vote, a moderate, or anything of that nature. We look at a guy like Gorsuch. Again, Gorsuch, pretty conservative guy, but his textualist approach to jurisprudence did take him to a couple of interesting areas this year in extending rights for transgender employees and ruling in favor of Native American sovereignty in a land dispute in Oklahoma. And when you read Barrett's writing, she is clearly, at least academically, interested in exploring the nuances of originalism and textualism. And we see in the current conservative court that there are gradations between these five conservative justices. You know, Roberts is not Gorsuch, and Gorsuch is not Kavanaugh, and Kavanaugh is not always with Thomas and Alito. So we don't know how idiosyncratic Barrett might be on the court. So I think that is relevant if you're a Supreme Court attorney and you're trying to win a case. Like now that you know certain things about Gorsuch, you might tailor certain arguments to try to appeal to his textual sensibilities. In fact, that is what was done in the transgender case. They framed a very creative argument that appealed to his philosophical worldview. If you're in Congress and you're drafting legislation, you want to know as much as you can about these people, because just maybe they're not going to strike down everything that you pass. That's the fear. I mean, if we get to a point where the Congress can't address climate and can't address immigration and can't do anything else on healthcare. I can go down the list. If they literally just strike down everything, for either crude philosophical reasons or crass partisan reasons, if that's what the end result is, that's obviously a very serious problem. That's not a tenable situation. But it could be that the idiosyncrasies allow Democrats, if they're controlling Congress, to craft legislation carefully that will make it pass muster. And it is possible that Supreme Court attorneys can argue cases in a way that will be appealing to Barrett or Gorsuch or Roberts or Kavanaugh, depending on the particulars of the case. And the other thing that's important here politically is how much of an imperative is it for Democrats to pack the court, to eliminate the filibuster and pack the court as soon as they get the chance? If the whole thing is rigged, if the whole thing is just fixed from top to bottom, the Supreme Court has already been delegitimized before that fact, then you'd say, sure, what are you losing by packing the court? I mean, the fear that I've expressed on the last episode was that if we can pack the court, they can pack the court. And everybody can pack the court as soon as they have the votes to do so. But you don't have a legitimate, independent Supreme Court anymore that has been largely insulated from political pressures, which was the whole idea. You don't have anything resembling stare decisis, where rulings have sustainability beyond administration to administration. There is a stability and understanding what the law is, because the court is a real final word. I don't think you throw that away on a hunch. You want to see things play out to some extent. And it's tricky because obviously if Roe got struck down or was severely weakened very quickly, real people's lives get hurt. You don't want to be cavalier about that reality. But people's lives will also get hurt if you have a fundamental destabilization of your democracy, with women's rights and beyond. So Democrats are in a very tough spot because of the circumstances. But I don't think that calls for hasty action. And that's why, even though you may say the whole process is illegitimate, the nomination is illegitimate, I don't care about the nuances of her views, because that's beside the point right now. That is beside the point as far as the main matter before us. But understanding the nuances of her and the other justices do have their relevance, if not literally today, right around the corner, assuming she does become a sitting Supreme Court justice. I'll leave it there for now. I hope that was good food for thought, good fodder. You may disagree vehemently. Feel free, if you disagree vehemently, I by all means share it in the comments or ping me on Twitter at Bill Scher. Whatever you want to do to tell me how wrong I am, I'm cool with that. And I'll come back with another episode of Scherable real soon. Take care.